Hi, everybody. My name is Fred Haber, and I'm the General Counsel at Copyright Clearance Center, and I want to welcome you to today's presentation of Copyright 101. This is a program that we at CCC present to our own staff from time to time and to other people from time to time, and we hope that it's of some use to you. I will confess to begin with, and a lot of you are probably familiar with this, I'm from New York. I talk fast. I'll apologize in advance for doing that, but what I will also tell you is, depending on the law school you go to, copyright is either a 2 or a 3 credit course, and I think that everybody will, who takes that course will tell you that it's nowhere near long enough. This is 90 minutes. This is not going to be a copyright course like you would take in law school. I'm going to try and touch on things that are of interest to you as text authors and some general copyright principles so that you have some idea of what copyright is all about. On the line with me today are several representatives of the Authors Guild, whom you know, Mary Rasenberger, Ryan Fox. They're going to help me answer questions as the time goes on. They're at their office in New York, and so I can't see them, and we're going to be trying to send signals to each other without doing that. But we're going to try and answer your questions as we go. Please feel free, as we said, to write questions into the chat box on the lower right-hand corner there. I will probably try to answer them as I go if they make sense to where I'm talking at that moment. Some things I will get to later. I won't even refer to those. And other questions I will come to either at the end of the program, and Mary and Ryan will help me with those, or we'll try and answer them as we go because you've identified something that I missed. Okay, here we go. You know that? Well, to begin at the beginning, most of us who practice law, in fact, most of us who practice copyright law are historians of one kind or another, and we like to go back to the basic source and purpose of copyright law in the United States. And that is in Article 1 of the Constitution, Section 8. There's this provision that you can see on your screen. Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. I've underlined some parts of that because if you're a copyright lawyer, you refer to this as the Copyright Clause of the Constitution. If you're a patent lawyer, you refer to this as the patent provision, the Patent Clause of the Constitution. Mixed in here are discussions of both kinds of intellectual property. The underlying stuff is copyright. Progress of science, yes, that we're talking about the 18th century. For them, knowledge was science. Science was knowledge. And what you all do as writers of text are you help propagate science. So it's the progress of science by securing for limited times to authors the exclusive right to their writings. We're going to come back to this as we go. We're going to talk about this as a sort of a touchstone as we go through the various issues that we're going to talk about copyright. So what is copyright law? This is a quotation from Section 101 of the Copyright Law. It's a system that protects original works of authorship fixed in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated either directly with the aid of, or with the aid of a machine or device. There are a lot of clauses in this sentence, and we're going to talk about several of them as we go through the day because they are a little bit different from what you might have expected. This is the Copyright Law of 1976. We'll talk about timing later, but that's why there seems to be this stuff about machines and devices and the question about whether things that were written in silicon as opposed to with a pen and paper were protected by copyright. And the Copyright Law of 1976 wanted to make clear that, in fact, it is. So there are 3 fundamental concepts of copyright law that you need to understand that to have a basis in what is protectable by copyright law and what's not. And we're going to talk about what's not in a few minutes. So for something to be protected by copyright, it has to be fixed. That is, in effect, it has to be written down. It doesn't have to be a pen and paper. It can be keystrokes into silicon in any way that fixes them so that they can be referred to again later. They have to be original. It means you have to have created it yourself. It doesn't have to be creative. It doesn't have to be interesting. It doesn't have to be beautiful. It just has to be original. And it has to be eligible. That is, it has to fall into one of the defined categories of works that we're now going to take a look at. The left column are things that are protected. The right column are things that are not protected. So you look down the left-hand side and you see right at the top, literary works. That's the fancy name that the copyright law uses to refer to what the rest of us probably would just refer to as text or text-based things. But also included under copyright, the same copyright law, are all these other things: musical works, dramatic work, pantomimes and choreographic works, pictorial works, sculptures, motion pictures, sound recordings, architecture. All of these are within the scope of copyright protection. Now, there are a couple of things that you should probably be looking at there and going, I see at least one thing missing, and I see at least one thing that doesn't make sense there. The one thing that's missing is software. Where's software? Well, in its unmatchable skill, Congress has decided that software counts as a literary work. That as writers of text, you should in no way feel diminished by the fact that software is also considered a literary work. But for the folks in Congress, I guess, because software looks like text, somebody takes a pen or a pencil or a keyboard and silicon and writes down a whole lot of things that look like words if only you could understand the language. And for those purposes, software is protected like a book or like a magazine article. Something that should bother you as you look at that list, however, is the fourth one down, pantomimes and choreographic works. Didn't I just say, and I did just say, that in order for something to be protected by copyright, it has to be fixed. That is, written down on paper or in silicon. How is it that a pantomime or a choreographic work fits into this list? Well, from the point of view of Congress, inherently, a pantomime or a choreographic work is really just as valid, protectable by copyright as any of these other things. But the question about fixation bothered a lot of people for a long time, and many of you may remember Georges Balanchine, who was a famous dance maker of the early 20th century. He passed away about 30 years ago, one of the famous people who brought ballet, if you will, into the modern times. And because he actually personally was very concerned about copyright, he and a bunch of his colleagues actually developed a system for writing down dance. Some of you may have seen it before. It's called lab notation. I'm not quite sure why, but it's called lab notation. It looks like, if you can read music, it looks like a musical staff where somebody just then smeared all the ink all over the page. I cannot for the life of me understand it, but it apparently can tell somebody who knows how to read it exactly where every fingertip on every dancer on the floor, on the stage, at any given moment should be. And that was a way in which choreographic works could be fixed for future purposes. Pantomime, maybe not so much. And the end result of this was, with the developments of the 20th century, the way those got fixed, of course, was through motion pictures. It got inexpensive enough to videotape a pantomime or videotape a dance. That was sufficient for copyright purposes, for fixation for copyright purposes, in order to ensure that these kinds of works get protected. On the right side of this column, on the right column of this slide, are a list of things that are not protected by copyright. And take a look at what's there. Ideas, procedures and processes and systems and methods of operation and concepts and principles of discoveries. I'll hold the last item for a second because it's a little bit different. But if you look at that top list, the first 7 bullets, what those really are can be summarized as ideas. That is something that is not fixed, and it is not, often it's not original. But in any event, it's not eligible because it's not encompassed within the nature of the kinds of materials that either the copyright clause of the Constitution or the copyright statute itself were meant to cover. Just to give you an idea of how to think about this, I could, for example, decide to write a story. actually I'm going to write a bunch of stories. And it's going to be about this kid who's an orphan, and he's living with his uncle and aunt. And one day, as he's getting towards high school age, he suddenly figures out that he's not actually like them, but he's actually a wizard. And he gets invited to go to wizard school. And he has all kinds of adventures at wizard school. And like any good kid going to boarding school, in the summer he has to go home and be with his relatives and lose all the fun of being at school. And I could come up with lots of books about that. And that I'm allowed to do. What I can't do is I can't write Harry Potter. I can't copy J.K. Rowling's books, because what she and I share in my hypothetical are an idea, which is not protected by copyright. Her work, however, which as lawyers say is the expression of the idea, her unique expression of the idea, is what is protected by copyright. So as long as my story about a wizard kid and the Harry Potter series are not copies of each other, neither is an infringement of the other. This is hard always to determine at the margins, because the line between idea and expression is not as clear as lawyers would like to believe it is, and I think we all know that. But the notion, and what lawyers and judges will always look at, is how much of what is taken is merely an idea, and how much is a unique expression, an original expression of that idea. This goes back to some of you who probably teach English classes, and it's been a long time since I took an English class, and I can't remember whether the number was 6 or 36. Some famous writer came out with a conclusion on analyzing all of great literature that there were only, whether it was 6 or 36, actual plots in all of literature, and that all the millions of books that have been written are simply different versions of these same handful of ideas. You know, guy meets girl, guy loses girl, guy gets girl, you know, whatever it is, guy gets pet, whatever it is. All of those things are limited in a very strict manner to fairly few ideas, the uniqueness of their expression being that which is copyrighted, and yet the ideas are not. The last item on that right-hand column I list as facts and data. Now, facts and data should be easy for you to determine as not protectable by copyright, even just from what I've talked about, let alone what you already know. And that is, facts and data are not original to the person who produces them. All right? They are the creation of nature, if you will. This is going to be a distinction, of course, between, for example, facts within a television program, which are all artificial, and facts in the real world, which are made by nature. And those will be distinct, and there are cases, and Mary knows them very well, there are cases out there that explore this line between what's a bunch of facts and what's protectable by copyright. But generally speaking, facts and data are not protected. This issue actually even had to go to the United States Supreme Court now about 25 years ago. Hopefully most of you are of an age that you actually remember the white pages of the telephone book. I'm not going to be able to do this very much longer, because pretty soon I'm going to be talking to people who don't remember the white pages of the telephone book, because they don't even know what a telephone book is. But bear with me for those of you who have a memory of it. One company sued another for infringing its white pages of a telephone book for a town, I believe it was out in Kansas. And went all the way up to the Supreme Court, where the Supreme Court held that no matter how much work is involved in making the white pages of a telephone white pages, which can be 1,000 pages long. Those of you who live in Manhattan can remember that. Quite a doorstop. There is no originality, and there is a public policy argument for not allowing the facts that are contained within that list, which is organized in the least original way possible, can be protected by copyright. That's a case referred to as Feist, was the name of the plaintiff in that case. Actually, the defendant in that case, but Feist was a Supreme Court case from the early 1990s that decided that, no, as hard as it is to make a telephone white pages, it doesn't qualify for copyright protection. In contrast, the yellow pages do, and there are a whole series of lawsuits that were involved around the yellow pages after the Feist decision, and the decision of the courts there was there is enough originality. Organizing yellow pages so that it's done by categories, and how you name the categories, and who belongs in what category, and how you lay out the ads in the yellow pages. All of these things are sufficient to create enough originality in a fixed work that the yellow pages can be protected by copyright. I realize that all of you are doing many more interesting things than white pages and yellow pages of telephone books, but they are meant by me to crystallize the issue about what's protectable by copyright and what is not. Okay, there are a couple of you have submitted a couple of questions. I will be coming back to these as we go. These are the kinds of things I am going to cover. If I don't, I will try and come back to them in a little while or towards the end. Okay, so having given you an idea of what's covered by the scope of copyright, what's not protected by copyright even though it looks like it might be? Something called the public domain. Like lawyers in every field, copyright lawyers have chosen to take a couple of words out of the dictionary and assign them a unique technical definition for purposes of copyright law. The public domain, not a domain because it's not a place, and it's not really public because you can't see it. The public domain is, by definition, all those works that are not protected by copyright. So the public domain is actually a whole lot larger than the copyright world because everything not protected by copyright is in the public domain. Relevant to what we're talking about, which is things that look like they should be protected by copyright but aren't protected by copyright, generally fall into these three categories. There are others, but these are the three big ones. The first one, sometimes the most important one, is works where the copyright has expired. Imagining that there were copyright in the days of Shakespeare, there wasn't, but imagining that there was copyright in the days of Shakespeare, all of his works by now would be in the public domain because even with a very long term of copyright, he's been dead over 400 years, his works would have become part of the public domain, meaning, by definition, nothing more than they are not protected by copyright and therefore eligible for copying by anybody. Second big category for those of us who live in the United States of works that look like they should be protected by copyright but aren't are works of the United States federal government. That is, let's go back to our civics class, the government is us, we are the government. As a consequence, if we write something, we should be able to have access to it. And that's really the principle underlying why the statute itself says, the United States Congress has actually said that works of the United States federal government are in the public domain, in effect, because they belong to all of us. There are niceties for those of you who work outside the United States who are worried about your works going outside the United States. There are little footnotes that I would attach to this line if you were talking about uses outside the United States, even of works of the federal government. But as a general matter, this is one way of thinking about it. Works of the United States federal government in the United States are not protected by copyright, no matter, no how. They have to be works of the U.S. government, not of contractors and not of friends and not of other people, but works of the government itself. This does not necessarily apply to state government. Depending on the state you live in, your state may try to assert copyright protection in at least those works which are not themselves laws. For example, studies and reports and research and things like that. It depends state by state. Some states are fairly liberal, some states are very protective, but you'd have to check your own state's laws to figure out whether a work is protected. And finally, and this was traditionally a very narrow collection of works, but is now growing in the world of the internet, works where the author has opted out of copyright protection. That is, you specifically, should you choose to do this, you specifically say, I'm disclaiming any copyright rights in this work I've created that's otherwise protected by copyright. There have been mechanisms put in place, sort of, to try and help you do this if you're so inclined. It's not easy to do. The presumption still is if something looks like it's protected by copyright, it is protected by copyright until you're certain that it's not. Okay. Okay. I'm seeing there are questions coming up. There are a number of you asking questions. We're going to try and get to as many of them as I can. Certainly between Mary and Ryan and me, we will answer these questions. If not, online with the group, we'll try and catch up with you afterwards or stay online past the end time of the session in order to answer them. Thank you for the questions. I appreciate them. Because a lot of you are probably here because although you make your living from copyright, you don't know a whole lot about it, but are interested in learning more. One of the questions that probably comes to you a lot at like parties that you go to where you say copyright and most people's eyes glaze over. Those of us who are lawyers are very well aware of this kind of problem. But those of you who write for a living or make your money from copyright for a living probably have had the experience of going, no, you're not asking me the right question. There are two other major areas of intellectual property protection that you should be at least a little aware of so that you can distinguish them from copyright. So I have one slide here, only one slide, about patent law. I will have one slide about trademark law, and that's it. This is just to give you a sense of how to distinguish it from copyright law. So what's patent law? Patent law protects inventions. Remember, going back to the Constitution on my very first slide. It protects inventions that are useful, novel, and not obvious. And they have to be all three. All right, those are words, again, that lawyers have taken out of the ordinary dictionary that the rest of us use and have given very specific definitions to. And in the patent world, because people litigate about them so much, there are thousands of cases about each of these three words and trying to define what they are. Generally speaking, useful is it performs a function. Novel, a little like original under copyright, is a specific defined term for patent lawyers that says it is new. It's not been done before. And not obvious, obviously, means that people didn't know about it before you invented it or couldn't have predicted it before you invented it. This is obviously something that is very complicated and gets litigated a lot because, for example, at the time of the beginning of the Internet, a lot of people were getting patents by taking totally ordinary things that had been done for thousands of years and adding software to the process and then getting a patent from the patent office because they said, well, gee, it's novel. Nobody would have thought to take this thing and add software to it, except they would have. And it's taken some time, but the patent office has been straightening that out. What kinds of things can be patented? Well, here are 4 different groups of things, and me not being a lawyer and not being terribly creative, came up with very simple explanations for it. Patent process, a process can be patented, which remember that was on the right-hand column of what can be protected by copyright, and it can't be protected by copyright, but it's a new way of doing something. It's what you think. So my example here is the idea of delivering a medicine in a capsule instead of a tablet may in fact be protectable by patent law if, for example, you're talking about, let's say, an acid that if you ordinarily put it in a capsule, it would burn through the capsule and wouldn't be useful, but you've come up with some way of ensuring that it doesn't burn through the capsule. Now you've got a process that you can protect with a patent. Classically, a machine is protected by patent law. Those of you who are history students remember Eli Whitney's cotton gin, supposedly made the South live for the 70 years between the creation of the United States and the Civil War because it was a magical way, if you will, from the point of view of those of us who can't invent anything, of separating cotton seeds from cotton balls in order to make the cotton useful for making clothing and things. Otherwise, you had to pick them out by hand, and that took forever and was very expensive, even with slaves. Third group of things that can be patented are manufactures. That is a human-made structure that has inventive characteristics. My example here is a new snow tire. That is, you have a particular way that the snow tire grips the road and sheds the water, and that's going to be protectable by patents. Fourth major area is composition of matter. If we were back 6,000 years ago or 10,000 years ago, whenever it was who figured out how to make bronze, made bronze, that would have been the ideal thing for a patent. It's a combination of natural elements in a new way that results in something useful. I think bronze is tin and copper. That is stronger than both of them, or stronger than either of them. Much better thing for making sculptures and things like that. A wonderful patentable invention before the world of patents. Today, this is commonly done in, for example, in biology, where like stem cells are used for creating biologicals and medicines and things. Patents last for about 20 years, and most people would agree that they are much stronger. They provide much stronger protection than a copyright does. A patent is only available from the United States, from the government, the United States or otherwise, and if you don't get it from the government, you don't have a patent, which is unlike with copyrights. We'll talk about that in a second. Okay, that's the end of patents. Briefly, we'll talk about trademarks. I always love it because our customer service people here at Copyright Clearance Center regularly tell me that they get the same old question. I've been here over 20 years now, and at least a couple of times every year, somebody calls our 800 number and says, I want to copyright my band. And our customer service people know not to go, what on earth are you talking about, but to help guide the person through the process of you removing the word copyright from the sentence and explaining what it is that they're seeking to do. The right question to get that person the answer that they want is, may I protect the name of my band as a trademark or service mark? And the answer is yes. A trademark law, trademark is a distinctive mark, symbol, or logo used to identify a product's origin and quality. So the most classic one, of course, is a word, you know, like Coke, an image, a logo, like Coke in that cute script that they use, a shape. Some of us are old enough to remember when Coke bottles actually had a swirl in the glass, which apparently they protected as a trademark. Not done anymore because it's basically too expensive to make those bottles. Many of you probably have bought insulation for your homes and imagine that it's always pink. That's the Owens Corning trademark. Insulation is actually kind of dull beige. They've painted it pink so that you'll think of it when you want insulation, you'll think it has to be pink, and you'll only buy Owens Corning insulation. You can also have a sound as a trademark. Da, da, da. If I've got the tones right, that's NBC. All of you recognize it as that. NBC was created by the General Electric Company, GEC. Trademark law is a species of consumer protection law as opposed to a species of property law. What I mean by that is it's not so much that you own a trademark as that other people recognize a trademark as belonging to you. And that is, as long as I recognize it as belonging to you, you have something valuable. When I no longer recognize it as belonging to you, like, gee, those are lovely nylons. I'm a little old. You used to say that. Those are lovely nylons. Once upon a time, everybody knew that you were talking about a DuPont product. Today, nylon is no longer a trademark, and nylon simply refers to the way in which a substance from which stockings, well, I guess they're not anymore, but could have been made. It used to be a DuPont trademark. It is no longer. And because it's no longer recognized as a trademark, because people no longer recognize it as a trademark, no matter what DuPont tries, DuPont can't get it back. As a result, the last bullet, trademarks can live forever as long as they continue in use. All right, we said patents can only live for 20 years. We'll find out that copyrights in a moment live not longer really than about 100 years. Trademarks can live forever. So Budweiser was first used as a mark on beer in the 1600s. For those of us here in New England, Revere, remember Revere, Paul Revere? His father founded the business. It was first used as a mark on serving pieces in the 1730s. It is still used on serving pieces today. I'm not even sure who owns the trademark anymore, but Revere is still a trademark going on now 300 years. Okay, so that's enough about patents and trademarks. Hopefully none of you has a question, but we can always come back. So back to copyright. Under Section 106 of the Copyright Act, which you can all go and look up, the Copyright Act is very long, and once upon a time when I used to teach this class here at CCC, I would actually hand out copies of portions of the Copyright Act. It's way too long. You don't need it. It's worthwhile taking a look at online because the convenience is you don't have to print it out. Section 106 lists the following rights as being part of a copyright. That is, a copyright is itself a collection of rights. The rights to reproduce, create a derivative work, to distribute a work, to publicly perform a work, to publicly display a work, and in an excess of caution in the 1990s, the music industry went back to Congress and got them to add the right to digitally transmit sound recordings. The right to digitally transmit sound recordings is what we all call streaming, and the music industry was worried that the other 5 rights listed here somehow didn't encompass streaming. As a copyright lawyer, I think it's at least in 2 of these, maybe 3 of these, other ones, but the music industry was nervous. Now, I'm holding my hands together, and this is something I usually do when I do it live. It's a little easier. I'm holding together a bundle, like a sheaf of wheat. And the phrase that lawyers use is that a copyright is a bundle of rights. And we'll talk about what that means. Now, if you look at this screen, if I asked you how many rights comprise a copyright, you'd probably say 6. I gave this class last week to a group of people in front of me, and for some reason somebody said 5, and I was never able to figure out why. Other people just sort of stared at me. The answer, if you tip over the bundle that you're holding in your hands of the sheet, like the sheaf of wheat, and you look at the top, you would expect to see 6 sticks in that bundle. But in fact, as copyright lawyers will tell you, the number is infinity. Now, for the math majors among you, you know that that will drive you crazy because infinity isn't really a manageable number. But what I mean by infinity is the following. If, for example, although Ryan and Mary are not here in Danvers with me, I'm going to pretend that they are because this is the way I can think about the example. If I go to Mary and I say to Mary, who happens to be, little did she know it, the owner of one of the 2 movie theaters here in Danvers, Massachusetts. And by the way, let me introduce myself. I have the blockbuster movie of the year. Everybody wants to see it. So Mary, I go to Mary and I say, Mary, I'm willing to license you on an exclusive basis the right to show my movie in your movie theater in Danvers, Massachusetts on Tuesday afternoons in months ending in R. And she says, okay, we have a deal. I've just conveyed a right to Mary, and because it's an exclusive right, the law actually says she now becomes a copyright holder, a copyright owner, actually. But let's set that aside. Now, you all may think, what a stupid deal. But let's say my movie is such a blockbuster that Mary's willing to settle for that. So now she has the right and she can show the movie, my great movie, in her theater in Danvers on Tuesday afternoons and months ending in R. And then I go across the street and there's Ryan. And Ryan is the owner of the other movie theater here in Danvers, Massachusetts. And he too has heard about my blockbuster movie and he too wants to show his movie and my movie in his movie theater. And I say to him, Ryan, I will do you the deal of the century. I will give you a license to show on an exclusive basis to show my movie in your movie theater here in Danvers, Massachusetts on Tuesday afternoons and months not ending in R. Now you can decide that's a stupid deal too. And by the way, Mary's probably kind of annoyed that I did that deal. But I gave each of them an exclusive right. The rights do not interact with each other because they're distinct. One has the months ending in R, one has the months not ending in R. And as little as the 2 of them are now happy with me, because I've now divided the market in a way they wish I hadn't, they each are copyright owners, and they're each entitled to sue somebody who does exactly what their copyright right allows them and only them to do. That's the reason why, until I started this deal with Mary and then with Ryan, I looked in my bundle of sticks, and I thought there were 6, and I pulled 1 out. In fact, I pulled 2 out that until I did the deals with Mary and Ryan, I didn't even know they were there. Nobody knew they were there. But they were in the bundle of rights. And by the way, I still have all the other rights left, so I can go to other towns and other movie theaters and license my things exclusively to yet more of them, creating lots and lots of copyright holders, and I still own the copyright ultimately in the movie. Complicated enough? Yeah, I'm sorry it is. Okay, let's go back to the definition that we had from Section 101 of the Copyright Act early on. And some of this may answer some of the questions that many of you are posting on the display. There are enough of them. I'm sorry to tell you, I can see them, and Mary and Ryan can see them, but you can't. But there's a very long list of them. I think it unlikely we're going to get to all of them now. But and I'm sure Ryan and Mary, if they could reach 200 miles, would kick me for saying this. But both of them and I are happy to answer your questions as we can, both after this session and at other times if we can. Okay, so copyright law protects the authors of original works of authorship. Now, those of you, most of you probably, because you're here as guests of the Authors Guild, are probably authors yourself, or you think of yourselves as authors, and you may in fact be authors. But the copyright law, in effect, makes a distinction between 2 words that you learned were synonyms. Copyright lawyers think of them as distinct, and that's the word author and the word writer. A writer is the person who holds the pen in her hand. and puts the ink down on the paper. The author is the person entitled to the copyright. If you work for yourself, you're both the writer and the author. If your writing is for somebody else, particularly your employer, then you're the writer and your employer is the author. And a way of thinking about this is, think of the biggest, richest, most obnoxious corporation that you can, and it is inert. It can't write a single letter. It has to employ people to do that for it. And it does that. That's how corporations work. It employs people, and in exchange for money, it gets them to do things. And some of the things it gets them to do is to write things down that are protectable by copyright law. When it does that, the writer never has copyright in the work of her hands. The author of that work is the employer. That's something called a work made for hire. The simplest example of that is when you're an employee and your job entails you doing writing, and you do writing for your employer as part of your job. That is a work made for hire. Once you separate that set of facts, which I think most people find easy to think about, from the many, many, many other sets of facts that Mary and Ryan, I'm sure, deal with in their everyday lives at the Authors Guild, things can get more complicated. What if you're commissioned to do a work? What if you do a work with somebody else? All of these kinds of questions make the question of work made for hire somewhat more complicated. And there are even Supreme Court cases that have tried to figure out when you can determine whether a work is a work made for hire, and therefore the author of the work is not the writer of the work. And I'm not going to be able to go into all of that here. But I'm sure that lawyer friends of yours and I, too, would be happy to talk to you about it on the side. Next bullet. Once upon a time, there was a distinction between published and unpublished works. There was a lot of law under the old Copyright Act where you sat there and tried to figure out when was a work a published work and when wasn't a published work. And that was when publishers, meaning companies with big printing presses, were a far more important aspect to copyright. Today, whether a work is published or unpublished doesn't matter for purposes of copyright law. Excuse me. If a work otherwise qualifies, it doesn't matter whether it was published. It's still protectable by copyright law. And as I noted before, the copyright law grants all those Section 106 exclusive rights to the copyright author, to the author of the work, who's now the copyright owner. And that right includes the right to authorize others to do so. That's what licensing is all about. In fact, that's the reason that CCC exists, is to help copyright holders do licensing under certain circumstances. Finally, as the law stands now, because it was subject to one amendment, works created on or after January 1 of 1978 are protectable until 70 years after the author's death. This is one of the reasons that those of us who practice copyright, not just copyright law, but copyright generally, have had to put on a second hat, and that's to become a genealogist. Because exactly now when copyright runs, it's usually relatively easy, not always easy, but relatively easy to figure out when a copyright starts running. It can be very difficult to figure out when it's run out. We'll talk about in a second something that a lot of you are familiar with, which was defined terms to copyright that no longer exists for works after 1978 because it lasts until 70 years after the author's death. That even seems to be an easy question, but I will tell you that copyright has always exercised authors. And a famous case that we all still are scratching our heads about is that Mark Twain, yeah, he of the white suit and the stogie, died in 1910. And he, as you'll remember, was a prolific author of books and short stories, most of which were wonderful, all of which I ever read I enjoyed. I hope you did too. But he was kind of annoyed at the author's plight and was disappointed that copyright ran out, and that therefore his children and his grandchildren wouldn't be able to benefit from his works the same way somebody might build a hotel and be able to give that hotel to her children and her grandchildren, and all of them have the benefit of living off it. And so Mark Twain actually wrote a book and then hid it, in effect, gave it to his literary executor, and ordered the literary executor not to publish it until the year 2010. Under the law in existence at the time of his death, he figured that his grandchildren or great-grandchildren at that time would have maybe 50 or more years of royalties from that book after it was published in the year 2010. Unfortunately, in the intervening time, the law changed to what you see on the screen, and the copyright runs out 70 years after the author's death. Mark Twain died in 1910. The theory goes, any copyright in any work he wrote ran out in 1980. His book was first published by UC Berkeley Press in the year 2010, pursuant to his will, 30 years after the term of copyright ran out. I still don't know, and maybe Mary knows. I didn't talk to her ahead of time. I believe the answer is that work gets no copyright protection. As much as Mark Twain tried to trick the copyright law, it came back and it bit him, and his work ended up with no protection, as opposed to the mere 50 or 56 years he might have gotten had he taken care of it had he published it before he died. Okay, some practical questions. Do you have to register a copyright? Some of you who are a little older, like me, think that the answer to that has to be yes, because it used to be yes. The answer today is no. You do not have to register your copyright because under the law, copyright adheres automatically from the moment an eligible work is put into a fixed form. Okay, so that doodle on the napkin from lunch that you put in your pocket afterwards is as protected by copyright as a 50-volume encyclopedia that was edited to a ne'er-do-well and to a fairly well and involved hundreds of people in their work. You do not need to register. They're both protected by copyright. Having said that, I will say there are benefits to registering. The Authors Guild will explain those to you in due course, and I think we have another program that's going to talk about that, among other things. It is worthwhile registering your work, particularly if you think you have an infringer that you want to sue, but you do not need to register your copyright in order to get copyright protection. There's some interesting questions coming along. I guess one or two that just, I guess, are related to the Mark Twain story. Is it possible, basically, to republish your work? That is, in a collection of your short stories, or in or you'd put out a second edition if that's the kind of work it is. And copyright law gets a little more than a little complicated in this area, but generally the notion is merely republishing something is not sufficient to earn it a new term of copyright. It's not new anyway, and by the way, since the term of copyright is until 70 years after your death, the likelihood that you're going to be changing it towards the end of that term is kind of low, so that's not a concern. As to whether the second edition, the third edition, the fourth edition of your works are protectable by copyright, the answer is yes. As a technical matter, the new material each time is protectable by copyright from the time it was protectable. That is, from the time you fixed it in the piece of paper. The stuff from the first edition remains under copyright, again, for life plus 70 years, but it doesn't earn a new term of copyright if that were even a meaningful statement anymore. Under the old law, which we'll talk about in a minute, it mattered, editions mattered because terms of copyright were fixed and they ran from the date of publication, and so it mattered when something was published. That is no longer necessarily true because of the life plus construction. That is, there's no such thing really as a new copyright in answer to somebody's question, because it doesn't matter whether there's a new copyright or an old. They're both going to run out at the same time, life plus 70 years. Do you have to use a copyright notice? Again, the answer used to be yes, or you'd lose your copyright protection. The answer today is no. A copyright notice is not required. At the bottom of that slide, you can see two typical copyright notices, one in the name of a human being, one in the name of a company. Those are, if you will, standard formations. The C in a circle, or the word copyright, or an identifiable abbreviation of the word copyright, the year, and the person claiming the copyright protection. In this case, CCC is my employer. I made this slide deck. I'm the writer. I'm not the author. CCC is the author. The appropriate copyright notice for this slide deck is what you see there. However, copyright notices are useful to use. They make it clear that you believe that this work is protectable by copyright, and it provides useful information to the user to find you if she wants to get permission to use your work, republish it, or somehow use it in some other way. Okay, there's a question there about why do publishers need to register a work? That's a little bit of inside baseball. The short answer there is in order to get retrospective protection for the copyright work for a copyright infringement case. That is, you don't get to sue somebody for infringement of an unregistered copyright. You can only, in the United States, you can only sue them for infringements that occur after registration, and the law permits a copyright holder, whether it's the author or the publisher or whomever, to get a 90-day grace period after the date of copyright creation to register the work in order to have the registration be, in effect, backdated to the date of creation for purposes of chasing infringers thereafter. Okay, a couple of questions have come up. Conveniently enough, I threw together this slide to answer the questions, sort of. Some of us are old enough to refer at the bottom of the slide to the new law, the Copyright Law of 1976, which became effective on the first day of 1978. It's been tweaked a little bit here and there since then, including most importantly for a lot of you, extending the term of copyright to what says here, 1998, starting in 1998, it lasts for the life of the author plus 70 years instead of plus 50, which is the international norm. For a work for hire, remember work for hire very often is the author is a corporation which doesn't have a life, or for a work written under a pseudonym, can't say the word that's on the slide. In either case, it lasts for 95 years from publication or 120 years from creation, whichever is shorter. This is the last place in the Copyright Act where publication supposedly makes a difference. Hard to tell what that means in this day and age when most of us post our work right there on the internet so that only 100 million people can see it. But we're going to claim it wasn't published because it didn't go through a publisher. Hard to tell what's going to happen in a lawsuit. But there's the term, so that the work of Copyright Clearance Center, this slide deck, is protectable for 95 years from this year under this provision, because CCC, I hope, and my children hope, will still be here in 95 years, but this copyright will have run out. Unlike if it was a human person, in which case the copyright would have died 70 years after she did. Okay. There are a handful of questions that are coming up about the technicalities of publisher-author relations and of author-trust relations and how things should be handled for copyright purposes. Mary and Ryan are reading these as well as I am, even though we're 200 miles apart, and we will try to answer these as time goes on. I would like to get through some other slides because some of these are, I realize they're important to you. I appreciate that. And somebody just put up the notice of the copyright notice for the autobiography of Mark Twain, which was published. That's not the right work. I don't think it's the autobiography that was published in 2010, but I don't know. The copyright supposedly is owned by the Mark Twain Foundation. That's certainly open to question. Not that whether the foundation exists or can make money from it, but whether in fact it has any copyright rights. The old law, the law that went out of effect when the new law came in, did require registration for protection of a work. If you didn't register on a timely basis, you lost your copyright protection. It also, notice was important under the old law, and actually for a brief time under the new law. If you didn't provide a copyright notice and you didn't fix the mistake promptly after identifying it, you lost your copyright. This was important because it would mean you couldn't win the lawsuit. You couldn't sue for infringement. You had no copyright. Those two things went away with the passing of the old law. Under the old law, the maximum term of protection was 56 years. That is, you made a registration. The registration was valid for 28 years. you could renew it once for 28 more years. That's how you got to 56. And there were all kinds of technicalities about how how to do the renewal, and people could mess that up and lose their copyright because they didn't do the renewal properly, or they missed the date, or what have you. Over the years, the very first Copyright Act, which was enacted in the United States by the very first Congress in 1790, copyright term then was 14 years for the first round, 7 an additional. There's something magical about multiples of 7, but the 14 and 7 creepy crawled up. It was 14 and 14, and then it was 28 and 14, till it became 28 and 28. That was either in the 1871 Act or the 1909 Act. It became good for up to 56 years. The problem with that, of course, was for those of you who were child geniuses, it meant that you could outlive your copyright. And the famous person who did and got very upset about it was Irving Berlin, the famous songwriter who wrote one of his most famous songs, Alexander's Ragtime Band, when he was 18 years old. Even though he protected it for 56 years, that lasted until he was 74. He lived to be 103. So for 29 years after he died, he would hear his music played and could not earn a dime on it. He was one of the motive forces behind, along with international norms being, making the term of copyright life plus a term of years. Finally, under the old law, there was no provision for fair use. And the significance of that, we'll talk about that for a little while now, is the significance of that was that judges needed to figure out how to fairly balance the ability of users to use works and the rights holders' rights under the Constitution to, in effect, be paid for what it is that they created. Because what we saw in Article 1, Section 8 was a lawyer's expression of a deal between the copyright creator, most of you on this webinar, and the public. And the notion was the state, the people, would grant a creator of a copyrightable work a monopoly in her work for a period of years. That's what the limited times it says in the Constitution, for a period of years, and in exchange for that monopoly, when it ran out, the work would be available to everybody. That's why we can all read Shakespeare. It lasts for a reasonable amount of time, thought Congress, whether you looked at that as 28 and 28 or life plus 70 or what have you, but it's not forever. And at the end of that time, the work that you've created becomes a property of everybody. It becomes a part of the public domain. That's one way in which users get a balance. Something that came up over time was that sometimes it's reasonable to use small parts of works. It was reasonable to use small, I turned the wrong page. I shouldn't have done that. I'm going to go back a second. It was reasonable to use a small amount of works in order, for example, to do criticism. How else are you going to be able to say, this was the most moving piece of work I ever read? For example, here's, what can you put in? A sentence, a paragraph, a couple of paragraphs? Not clear what you could put in. And over the years, starting in the 1840s, courts developed a set of rules of thumb as to how much you could take from somebody else's work in order to make what came to be called a fair use of it. We're going to talk about fair use in just a couple of slides. You saw that I jumped ahead to that because I forgot to turn over one of my pages, and I thought that I had fallen behind. But we're going to talk about fair use, and that's going to be sort of the closing subject that we can shrink or expand as necessary in order to ensure that we get to as many of your questions as we can. So, in 1998, all right, remember, the Copyright Act that currently exists came into effect on January 1 of 1978. 20 years later, one of the big things that had happened in the intervening time was the creation of the Internet and the creation of digital works generally. And there was a series of questions raised as to whether works that weren't ink on paper, works that weren't sort of physically visible, were protectable by copyright, the same as the traditional written works, artwork, sculptures, even architecture would be. And because the questions were extant, and even though most copyright professionals were pretty comfortable saying that, in fact, all that stuff was protectable by copyright as well, because just as we went from pencils to pens, and just as we went from fountain pens to ballpoint pens, it shouldn't be a big deal that we go from ballpoint pens to typewriters to electronic typewriters to typewriters that don't write on paper but write in silicon. And so we were pretty comfortable with that. Enough people were concerned, however, that Congress revisited the Copyright Act in 1998 to make it clear that the use of works in digital form, as opposed to in physical form, were just as protected by copyright as the works in physical form. This was part of an international movement. The United States joined joined one international treaty that said the same thing in order to make sure that the copyrighted works of Americans would be protected around the world. That was the driving purpose of the Digital Millennium Copyright Act of 1998, the DMCA. It also installed a couple of things relative to the Internet, like making it illegal to manufacture or provide devices that circumvent usage controls, what was once upon a time called DRM, Digital Rights Management, or Digital Resource Management. It became illegal to alter, remove, or falsify copyright management information or metadata. In exchange, and this is one of the glories of the Internet era, it limited the liability of Internet service providers, both for copyright infringement and actually for some other things like, frankly, porn. As long as the Internet service provider didn't have a hand in deciding what was posted, then it would be treated just like a telephone company. You can plan all the crimes you want on a phone call with your co-criminal, and yet the phone company will not be liable for what you talk about. The Internet service providers wanted the same protection, and they got it. There's some other changes wrought in 1998, and one of the things that was important from the user community was to ensure that none of these changes, which were all designed, it was seen, to help protect copyright holders' rights, would not impact on fair use. That's what the small print at the bottom of that slide is trying to talk about. So, okay. There's some interesting questions. We are going to come back to them, but I want to sort of finish a few other thoughts before we do that. Up on the screen are a handful of current issues in copyright relating to text. There are lots and lots and lots of other issues relating to photography, to music, to motion pictures, to broadcasting, and things like that. A list like that would go on for many, many, many slides. This is a handful of things that are, I think, of most interest to those of us on this webinar whose principal interest is in text and text-based publishing. And you've probably heard a few of these. I know the Authors Guild has been involved with a few of these. This is separate from anything having to do with the Google book search case or anything like that, which I will acknowledge to Mary and to others, was on this slide until recently as a current issue. These are still some remaining current issues. Orphan works, the question of what can a user do with a work that is clearly subject to copyright, but where the copyright owner either can't be found or refuses to answer a request for permission to use. This is an issue around the world. In the Internet environment in particular, it has become more and more prominent because so many people publish their materials on the Internet and then promptly forget about them and don't necessarily leave a trail of breadcrumbs back to themselves in order to help you find them in order to ask permission to use. Congress has tried to address this a couple of times over the past 10 years. There are a lot of reasonable questions about any statute yet that has been proposed, whether it's going to fairly treat copyright holders. The people who were originally proposing this kind of legislation were museums and archives and people like that. Plenty of people who are owners of copyrights, including authors, were concerned that this would be seen as a shortcut to infringing works by saying, oh, I looked for them, I couldn't find them, and so I used it, when in fact no particular effort was made, which was also something that turned up in the early stages of the Google book search case and was a problem on the user side. Next up, and for those of you who publish nonfiction in particular, and in particular those of you who publish science and technical materials, or who write science and technical materials, there is, the best thing to call it is a movement afoot called open access. The principle of open access very often in the science field is because you, the person who created the written work, were funded by the government through a grant, whether because you're a science researcher or you're a science writer or what have you, you therefore have already gotten paid for the work, and therefore the work was in effect paid for by the government, and works of the government or that are paid for by the government should belong to us all, and therefore these works, though nominally protectable by copyright, should be freely available for anybody to use. Those of you in science know that this is a big issue. It has not started to reach outside of science. It's hard to see how it will, but I've learned never to say never. Major science publishers are very concerned about this. Science authoring groups, science writer groups are also very worried about this. Some of this comes from the third bullet on the screen, Creative Commons. Creative Commons is a small not-for-profit organization basically funded or founded by authors, founded and run by lawyers for the benefit of a group of large users of copyrighted works who believe that a large number of creators of works, including authors of works, don't have any serious interest in doing classic commercial licensing, but are more than happy to see their work publicly used by anybody, provided only that their name is attached to it and that the work is not somehow used in a wrong way. That's the limitation of the license, and that no fee should be involved. If you go to the Creative Commons website, you will find a set of licenses written there that are all valid under pick your country. Any of, I think these days, 30 countries' laws. It started in the United States, but it's been transferred into a lot of other countries, whereby there are different licenses you can apply to your works that don't involve the payment of money for the right to use them. Some of them are more strict, that is, only certain people can use them and only in certain ways. Some of them are very lax, you can use it however you want, provided only that you keep my name on it. And ultimately, and this is something I mentioned many slides ago, the Creative Commons has created a public domain dedication form that says, I don't want any copyright protections here. That's referred to as the CC0 license. Although it's not a license, it's a commitment of a work to the public domain. That is no copyright protection. The other two works are things that have gotten more businesses involved, I think, these days than individual authors. Cambridge University Press versus Georgia State University is a lawsuit about the Georgia State University's creation of course packs by copying chapters and sections of books and not paying for the privilege of doing so, and then distributing those to students so that the students don't have to buy the books. And the last item is Copyright Office periodic rulemaking processes to create little loopholes in the DMCA restriction on creating devices that can break electronic locks on copyrighted works. Simply stated, I'm sorry if I'm going really fast, but I'm going to be done very shortly. Infringement is simply the exercise of one of those copyright rights, including one of the ones that was invisible until I pulled it out of my little stack, that's reserved exclusively for the copyright owner without the authorization of the copyright owner. So, for example, making a commercial quantity of course packs, classic example that CCC was created to try and address. To make new versions of works that can only be done, if somebody wants to make a movie out of a Harry Potter book, you need to go and get J.K. Rowling's permission. She has the exclusive copyright rights in that, but she can authorize other people to use it, and ordinarily she does that under a document characterized as a license, and she gets paid a royalty under the license, under whatever the terms of her license would be. These are what, when you go outside the scope of your authorization, either because you don't have permission, well, because you don't have permission of the copyright holder, you are an infringer and subject to a lawsuit, and there's lots and lots of other cases that I'm not going to go into about how you conduct one of these lawsuits. So finally, my last prepared topic before we go to some of your questions, which I'm going to be more than happy to get to in a second, is to talk a little bit about fair use. Again, this is another one of those instances where lawyers, and it's not just copyright lawyers, take ordinary English words out of the dictionary and give them extremely specific legal meaning. And what we usually do, just to confuse all of you non-lawyers, is that we give them legal meanings that are sort of like what they mean in the English language, but not quite. So what's fair use? Generally speaking, fair use is it permits the use of a small portion of a copyrighted work without asking permission or paying a fee. The very easiest example is quoting a sentence in a review. How am I going to say how great this work is unless I can show you a little example by what flowery language the author used in her book? And here's a sentence or two. And nobody, not the original author, not the publisher of the review, not anybody thinks that that's really an infringement, even though it technically is under the original, very draconian reading of copyright law. Everybody agrees it's not, it shouldn't be an infringement, and fair use developed to address that. It's meant primarily for socially productive purposes, although you and I will dramatically disagree if I'm the writer and you're not as to what's a socially productive use of my work. And the kinds of use that are mentioned in the statute as likely to be fair use, but not always. Just they're seen as often fair use are criticism or parody, news reporting, classroom teaching, scholarship and research. These are the areas that are talked about specifically in the statute. If you're not going to read any part of the Copyright Act other than one, this is the one to read. It's only 2 sentences long. It doesn't help you analyze it doesn't give you the answer to every case. What it does is it sets out a test that helps you determine whether a particular use is a fair use of a copyrighted work. And the 4 fair use factors that are stated in the statute are up here on the slide. How's the work being used by the second comer? What's the nature of the original work? How much and how important is the portion of the original work that's being used by the second comer? And what's the effect on the potential market for the original work of the proposed use? These are the 4 statutory fair use factors. They're not exclusive. That is, both the statute and every judge will say, if you can come up with something that is like these but doesn't fit under one of these and you can convince me that it's something that I should take into account, I will take it into account. The statute doesn't forbid me from doing that. So what does that mean? Some of this will answer some of the questions that have recently come in, I think. So the first fair use factor is how is the work being used? That is, how is the second user, or how is the user of the copyrighted work using the copyrighted work? Is it a socially productive use? What does exactly that mean? Not clear. There are a lot of cases about that. Is it a commercial use or a non-commercial use? That's not the most obvious thing in the world either. The classic example I give for the difficulty raised by the question about commercial or non-commercial is the following. Harvard University, which is down the street from here, is actually one of the largest charities in the world. It does a lot of good works. It runs a lot of educational things and does all these other good things that the tax law in the United States says should make it a tax-exempt organization, which we usually see as being a non-commercial organization. However, it uses some of its assets to run programs that will cost you $30,000 for 2 weeks, which clearly is going above and beyond the cost of doing business. Hold that in your mind for a second. On the other hand, you've got, let's pick one, Exxon or Pfizer, huge commercial organization, makes hundreds of billions of dollars a year, and yet is one of the largest providers of what you and I would call charity in the United States. And it does a lot of good, Pfizer in particular does a lot of good deeds, helping cure people of diseases, helping care for young children, all these kinds of things. The question to you is, when Pfizer's doing charity, and when Harvard is selling at very high prices the services it has, which one's commercial and which one's non-commercial? And I'll give you a hint. Nobody knows. However, under the fair use factor, under this fair use factor, that's certainly an argument that's going to be made. I gave you two extreme cases. Most cases are a little easier to look at. Another one is, did the user act in good faith? That's another question under the first factor. Was what the user doing, did he or she honestly think this was for a socially productive purpose and was not expecting to suddenly raise $100 million because somebody thought it was a great idea and showered them with money? That's the first fair use factor. And the question under the first fair use factor, is the use in question more likely fair use or less likely fair use? It's not an on-off switch. It's a dial. Is it more or is it less? Not is it or is it not? Same question on the second fair use factor. What's the nature of the work? Remembering, as you will, from my little two-column slide early on, at the bottom of the right-hand column was the words facts and data. The notion being that facts and data are not protected by copyright. We got that. We all know that well now. The question here, though, is what about a work that's primarily factual? Not so much as like the white pages of the phone book, but basically a news article. Who, what, where, when, why, and how. That's all it does. It just reports what the reporter saw and maybe has no opinion. Is that as protectable by copyright as, say, Harry Potter, which was definitely the creation, an original creation of a very creative mind. So under the second fair use factor, there's some question as to whether factual works should be treated as more subject to fair use than a truly creative work like a novel. There's questions relating to the nature of the work. Was it published or unpublished? Should you be able to take something out of somebody's drawer and use it under fair use, even though they never used it at all? What about a picture or a graph? How do you sort of use a little bit of it, or how do you use it for criticism without taking the whole thing? So the question then again is it more likely fair use or is it less likely fair use? Not is it or is it not. The question is, where on the dial does it fall? The third fair use factor is the amount and importance of the material used. That is, the more you use of the original work, the less likely it's a fair use. That seems reasonable. On the other hand, it's not a mere count. It can never be a mere count because for example, taking 10 pages doesn't seem like a lot, right? Because you're assuming it's a 300-page book. But it's only a 12-page work. So saying that 10 pages is okay when it's only a 12-page work, suddenly you've just taken 5/6. That doesn't seem as okay. That sounds like taking 250 of the 300 pages. Suddenly it seems like a lot. So no, there's no bright line as to what's too many or what's too few. At the same time, some works just inherently have something really important about them. And the classic case, again, this went to the United States Supreme Court, was the autobiography of President Gerald Ford, the 36th president, no, 36th, 7th, 8th president of the United States. Many of you will remember Jerry Ford, extremely nice man. Only man who ever served as president of the United States without ever being elected to the office or to being vice president. He was appointed as vice president, and then he succeeded to the presidency when his predecessor, Richard Nixon, resigned. That's connected to the Watergate thing. That's a long time ago, but it's still useful for copyright purposes. After he lost the election in 1976, he did, by the way, sign the Copyright Act of 1976, nice tidbit. But after he retired from the presidency in 1976, he lost his re-election bid. He wrote his autobiography, and as was the wont in those days, he gave it to a publisher who did a deal with a magazine to publish an excerpt from the magazine in the week before the book was going to go to press and be available at your local bookstore. And somehow another magazine got a hold of in exchange for that, the magazine that was going to publish the excerpt gave the publisher and the author a substantial amount of money, or promised a substantial amount of money. Somehow in the dead of night, the excerpt ended up, I don't know what the right word is, ended up in the hands of another magazine who promptly published the excerpt before the people who were going to publish it for money got to publish it. And they then quit the contract so that the publisher and author got nothing. And the publisher sued the second magazine for infringement. And the defense by the infringer or the alleged infringer was, gee, I only took 350 words out of a work of 150,000, right? Took about one printed page, page and a half, out of a book that was almost 300 pages long. Seems like a really small number. However, those of you who are American history students will remember that the one thing for which Jerry Ford was absolutely the most famous was pardoning his predecessor, Richard Nixon, of any crimes possibly connected to the Watergate scandal. And the page and a half that the second magazine took was the page and a half out of the book that explained President Ford's thinking as to whether and why he should pardon Richard Nixon. That's all that was taken. And the United States Supreme Court, including two members of the court appointed by Jerry Ford, concluded that this, despite the shortness of the taking, was the only important thing in the autobiography, in effect. They didn't say that, but what they said was, this was the heart of the work. That was the phrase they used. This was why anybody would buy Jerry Ford's autobiography, not to hear how he played football at the University of Michigan, not to hear how he was a congressman from Grand Rapids, Michigan for 25 years, but to hear why he thought it appropriate to pardon Richard Nixon. And the United States Supreme Court said that that taking of 350 words out of 150,000 constituted an infringement. That's not very much. Fourth fair use factor is the effect on the potential market for the copyrighted work. In essence, the law doesn't want to unreasonably restrict the ability of one person to sell or license their work by allowing another person to give it away. So the question is, how many copies, in essence, or how much of it can you take, or how is it going to affect the copyright owner's ability to make money from the work? Because that's the deal of the copyright law. You get a monopoly, you get the right to make money in exchange for your work being available to the public for money in the short term and for no money in the long term. This is a balancing that's very difficult for judges to make, because it is not true, as your typical copyright holder might want to say, is every copy I don't sell that's sold by somebody else is a copyright. I'm sorry, every copy that's sold by somebody else is a copy I didn't sell and I didn't make money. The law is not going to say that that's a valid conclusion. Neither is it going to say, it doesn't matter if I take this one because the author will make money someplace else. That also is not true. So between those two extremes is a balance that the judge has to make, that's argued by the parties, by the copyright holder and by the user, as to how much can be taken before the copyright holder's market is in fact affected in a material way, and the financial return to the copyright holder, the author, the publisher, whomever, is materially affected. And again, the question is going to be to the judge, is it more likely fair use or is it less likely fair use? And as I said the same thing as to each of the four fair use factors, and then what the judge is supposed to do after thinking of this, is it more, is it less, as to each of the factors, she's supposed to combine all four factors and say, well, on balance across all of them, is it more likely fair use or is it less likely fair use? This is very hard. The point of my talking about it at length today is to give you the idea that fair use is not automatic either way. In every case, it's a matter of fair weighing of the various interests of the user and of the copyright holder and of the public to see that the copyright bargain, that copyright holders are properly compensated, but don't have an absolute guarantee that of being paid for everything, is somehow carried through. And the bottom line is, as Mary and Ryan will always tell you when you talk to them at the Authors Guild, and as you will talk to anybody at CCC if you ever call here, the answer to a fair use question always is it depends. Right, Mary? Right, Ryan? I'm sure you're laughing in your office right now. The question then always becomes, what does it depend on? And what I tried to do today is to give you some idea under the fair use analysis as to what it might depend on, whether something is or is not fair use. Now, what I'm going to do is, this is my last formal slide, and I'm going to take questions, and we're making it possible for Mary and Ryan to log into the microphone as well. and we're going to redial back up into some of your questions here so that we can answer them. Officially, a simple question I can answer now is, officially this program is supposed to end at 3:30. We are not, the axe is not going to drop at a particular moment. We're going to try and keep it close to 3:30. In the meantime, okay, I'm going to leave these telephone numbers up so that you can, if you have questions about the presentation, you can contact us at CCC at the first paragraph, education@copyright.com, or that telephone number in Eastern Massachusetts. Or for more information about joining, about joining, visit the Authors Guild website at authorsguild.org/join. Contact Nicole on the staff at staff@authorsguild.org, and Nicole will make sure that your questions get passed through to lawyers and other professional staff at the Guild to answer questions. Having said that, I'm going to try and cycle through a couple of the questions here that I think we haven't yet answered. Sure. Let's scroll down a little bit.
Fred, hi, it's
yes,
Mary. Hi, everyone. It's Mary Rasenberger. So I can take a few of them. I actually was able to read them while you were talking. First, I want to just mention there are more of these coming up. There's a next week, there's registering your copyright on August 27th. Negotiating rights is November 15th. Monetizing your content is November 30th. That's about how to get your rights back and then what to do with them when you do. So I don't know if Fred mentioned, but one of the things I did in my past life was I oversaw the Copyright Office's rewriting of their compendium of practice. So one of the first things I can take on are some of the registration questions, and I'll go through them relatively quickly. First, there were some questions about different, publishing different versions. Should you publish new versions? Can you register a work once it's published and unpublished? So let me just answer them all at once. So you can only register each work once, okay, with a couple exceptions. And by work, I mean like that single edition. You can register an unpublished work and then register it again when it's published. However, you don't have to. There's no reason today to register an unpublished work, in my view, because unless you're worried about somebody infringing it, unless it's out there, but generally if it's already out there, it'd be considered published. And if you're going with a traditional publisher, or most publishers will register your work for you. Somebody asked, why does the publisher need to register it within 90 days? The reason is that there are a number of advantages that come from registration, which Fred mentioned a few of them. One is just you're providing people with notice that you're claiming the right. They can look you up on the Copyright Office's website and find you. But also you need registration to bring a lawsuit. And last, you need registration to get statutory damages and attorney's fees. And the statutory damages are damages essentially that are set by statute. You don't have to prove your damages. You can get up to $30,000 per work or $150,000 if the infringement was willful. You only get those statutory damages and the attorney's fees, meaning the other party, if you win and the case you can show was not necessarily reasonable, you can get your attorney's fees paid by the other side. Those two remedies are only available if you register within 90 days of publication. Okay, so the reason you want your agreement, and a lot of publishers push back on this, believe it or not, because they say, well, we don't always get them registered in 90 days, and we don't want to be responsible. We don't want the author coming and suing us. But you really lose rights if you don't, very important rights, statutory damages, attorney fees, if you don't register within 90 days. So do make sure that your agreement requires the publisher to do that. Okay, so for new versions, new editions, the rule of thumb is that if you add any new copyrightable content to a book, or you change it so that you are, in essence, creating new copyrightable content or new work, you should file, again, for registration to cover the new material. The new material won't be protected by a registration, meaning you couldn't sue on it if you don't register the new work. And the Copyright Office will register new versions as long as there is new copyrightable content. And in fact, they advise that you do. And Chapter 500 of the compendium, which is available on the Copyright Office's website, goes into detail about a number of different examples of, when you might want to register a new version and how you do it. Generally speaking, it's going to be a derivative work. So that new registration, and what a derivative work means is that it's a new work based on an old work. The new registration only protects the new material, okay? So it's really with the new version registration, you're doing it to protect the new content. The old registration still, the registration for the old version still protects that. There were some questions about having, somebody asked whether you can get your moniker protected, a title, a logo. Those are not protectable under copyright. Fred touched on that. It may be protected by copyright law, but generally speaking, short phrases, titles are not protected by copyright law. Let me see. Okay. If you publish a lot of different works, let's say photographs, and this is a big issue for photographers, do you have to register them all? Absolutely not, except if you want to sue on them. And of course, one issue that photographers have, because they have so many works, is registering within the 90 days. They often lose this. If you don't, you lose your right to statutory damages. Less of an issue for authors, of course, because there are fewer works. It's relatively cheap to register. So it makes sense, even for your stories. I would register them. And I should say that if you're a member of the Guild, we do have a new service to help with copyright registration. There was also a question about if somebody's plagiarized your work, it's all over the internet. Oh, you said the material's already all over the internet, but this person's selling the book for profit. Can the Authors Guild help you with this matter? Yes, if you're a member, we definitely will help you. We do this, we help our members all the time with this kind of thing. We would obviously need to talk to you. You would submit an inquiry to staff@authorsguild.org, and we would get back to you. We'd need to analyze it to see if the use is a fair use, what the nature of it is. We might send a cease and desist if we have no conflicts, or in some cases, if it's, been put up online on an internet service that allows users to post, then we might suggest sending a takedown notice under Section 512. And we will be providing more of those services in the not-too-distant future, takedown services with another organization, the Copyright Alliance. Okay. There were a few questions about getting your rights back from your publisher. So let me just address that very generally. Somebody asked about getting digital rights back. Somebody else said, what procedures do you have to go through? So the main thing you need to understand about getting rights back is that it's determined by your contract, generally speaking. So you do need to look at your contract and see what it says. Were the digital rights ever given? Were they circumscribed? If they weren't exercised, did they have to be given back to you? If, generally speaking, most contracts have an out-of-print provision that says that if after a few years, if the book has been out of print or hasn't been in an electronic edition for a couple of years, you can then write the publisher, send them a notice saying, I want my rights back. They often then have the ability to come back and say, well, okay, we're going to put it back into print in 6 months. If they don't, then you have the right to, then you get your rights back. But usually you usually do have to provide a notice. Sometimes it says you have to send it by certified mail. My advice is just read that provision and follow it very carefully, because if the contract says you have to do X, Y, and Z in order to get your rights back, you better do X, Y, and Z and not X, Y, and U, or only X, Y, okay? But you have to take the terms of the contract very literally. And again, we do help our members with that. We do that all the time, and the November 30th webinar will be also help you with, once you get your rights back, okay, now what? How can you exploit those rights on your own? I think we're running out of time. The fair use questions, I think Fred did a great job of answering. The one thing that I want to say about that is, of course, there's no single rule. There's no set number of words you can use, no set number of stanzas of a poem or a song. It depends, as Fred said, how long the poem or song is. I will say, though, that publishers sometimes require licenses even where it's clearly fair use, and that is something that we do want to address with them, because the author is usually responsible for acquiring the rights, the clearance, and paying for it. And we've seen cases where it's like 2 lines of a, 10-page poem. So I'll stop there.
Here, still acres longer? Oh, my. Sorry.
Fred, was that you? Yeah. So yeah, I don't know if there's anything you want to add. Yeah, it's just, I strongly believe that using a few lines of a poem, particularly if it's not a very short poem, in a book, in the context of some context where it's being described, or, the poem is being talked about, or it's being used for its historical significance or context in some way like that, it generally is fair use. But often publishers are more stringent about fair use than is really required under the fair use laws today. Not often, but sometimes. So
right.
It's worth pushing back, is what I'm getting at, when your publisher says you've got to go clear it. And
right.
again, if you have a question and you're a member, we'll help you out with that.
Right. Publishers will vary tremendously based on their own experiences, just as authors will vary tremendously, I think. There are a handful of other questions, Mary, and you can see them as I can. What I think, if it's fair to say, I think we can say that this is I will stay on certainly for a little while and answer some of the additional questions that we have. For the large number of people who were with us for this last hour and a half, we thank you sincerely, both we, the Authors Guild, and we, Copyright Clearance Center. Thank you for attending. We do hope you're going to attend the next in the series of webinars that Mary described. They're all coming up. I believe you've all received flyers, at least electronically, about them. But I will stay on to talk about some of these copyright questions that are remaining. They tend to be unique to individuals. They tend to be a little out of the ordinary. I don't think they're terribly much of general interest, but you're all welcome. I will assume that some of you are listening just for the curiosity, and you're welcome to stay. Otherwise, we'll see you. Is it next week, Mary, is the next session?
It is, yes, October 27th, so a week from today.
We hope we see you all next Thursday. And meanwhile, we'll go on. Mary, you want me to? I'll just start answering a couple of these as well. I'm about halfway down.
Okay, and there, just so you know, the questions that I still haven't answered that I could are about copyright term, because there are some nuances here in some of the questions that I can get to.
All right.
Okay.
Yeah, well, we can just sort of go through them in the chronological order here.
Okay.
I'm about halfway down about a copyright in a lawsuit. Somebody asked whether somehow a copyrighted work being involved in a lawsuit affects its copyright status. So the short answer is no. There's a distinction that I didn't elaborate on between the copyright in a work and the physical embodiment of a work itself. You all know what that really is. The notion of a copyrighted work is that ethereal thing that constitutes the literary work as opposed to the physical object that embodies it. Sometimes when there's only one copy of a copyrighted work, and it appears that your question, that's the case. It's whether they were notes or they were letters or what have you, there's only one copy. The fact is that you may remain the copyright holder. You may not have any access to the physical objects, and you don't have any right as the copyright holder to the physical objects that embody them. I'm sorry about that, but you will not lose copyright protection, but you may lose the ability to access the materials. They can, in fact, take them away so that you can't see them again if they have them lawfully. If they don't have them lawfully, then you have a stolen goods question, and you should really be talking to a lawyer, and probably not a copyright lawyer about that. Do you see where I am, Mary?
I sure
question?
do, yep.
Okay, so we can go on down. I think we did the commercial versus non-commercial.
Right. So that question, I'll just jump in. That you were somebody's saying that they're non-commercial entities, so they can use your work. That's not necessarily true. I think, Fred, you did a really great job of explaining fair use, and non-commercial uses are not necessarily fair use by any means. And if somebody's using your work on their website and they're using the whole work, obviously you'd have to look at the context and the work itself and the website, but I think that it very well may not be fair use, even though it's a not-for-profit site. There's nothing that gives, not-for-profit entities the right to infringe, and
right.
Just to call it fair use. Right.
I think you answered a lot of these questions coming up, down to the poetry, the relationship with the publisher. Storing a manuscript in the cloud, what right does the cloud vendor have? The cloud vendor has the same right, if you will, as the person who owns your bookshelf. If they are entitled to take the bookshelf away because you didn't pay for it, they may take stuff away, but you don't lose any copyright rights. This is a distinction between the physical object, even if it's in software, and the copyright itself. That is, somebody may have the copyrighted work, may have the only copy of the copyrighted work, and you don't have it, so you can't use it, and they can't use it because they don't have copyright rights. They need your permission to use it. In some sense, you're a co-owner in that individual copy. In some sense, you don't have any right to the physical copy, but they don't have any right to exercise copyright rights under it. We'll pass the Mark Twain question.
Yeah, so the Mark Twain question, I could add a little bit there, because it actually, believe it or not, the copyright law has a lot of little arcane rules, particularly when it comes to duration. And why don't I jump in now and talk a little bit about duration before 1978 and after. So what was going on before 1978? The second term kept getting extended. So as Fred explained, it was 28 years. Okay, and just to be clear, to get that initial 28 years, you had to publish or register. You didn't have to register, though. So published works, to get a copyright, you didn't have to register for that first 28 years. However, if you wanted the second term, which was initially 28 years, you did have to register, or they actually called it record. You had to record your renewal in the Copyright Office. So you didn't get that renewal or that renewed term unless you filed in the Copyright Office. Okay, but but that was actually amended in 1992. So that need to record the renewal in the Copyright Office actually ceases as of 1964. So one thing you know for sure if you're looking to use a work is anything that was published and had to be renewed, where it was out of its first term in 1964 and it wasn't renewed. So I'm not doing the math real well. That takes you back, I think, to the late 30s. If it wasn't registered or recorded after 1964, it's still in copyright. Okay. That second renewal term in various amendments to the Copyright Act before 1976, it kept getting expanded. In the 1976 Act, with the intervening amendments to the 1976 Act, it is now you get 67 years for that second term. So somebody asked if something was created or first published before 1978, does the new law or the old law applies? Actually, the old law applies with the updated amendments. It's the new law. It's in the 76 Act, but it's a different section of the Act. It's 304, not the governs not the life plus 70 rule. So what you have instead is a second term of 67 years. So you do have to do some calculation. And again, you automatically got that second term if after 1964, before 1964, you would have had to record the renewal or register in the Copyright Office. So I know it's a little complicated, and when you're dealing with duration of older works, it's actually usually a good idea to get a copyright lawyer because there's all of these kind of weird nuances to it. Let me see if I answered all of those questions. Okay. Oh, somebody also asked about a collection of a work. This is a really good question. So if you have a collection of an author's work, is that a new way to keep the writer's work under new copyright? Am I jumping ahead?
No, you're fine.
Okay. Oh, and I was going to go back to the Mark Twain question. So, but let me first answer that. Is that collections of works actually do have a new copyright, but it's a limited copyright. The copyright is not in the author's work, whether it's the stories, the chapters, the novels collected, whatever. It's called a compilation copyright, and it's in the way that the works are arranged and what works are selected. So, and believe it or not, and that was the copyright in the yellow pages in the Vice case that Fred talked about earlier. So if you have just even minimal originality in the way that in the works that are selected to be in a compilation and the way you arrange them, nobody can copy that. Somebody else could come along, though, and do a separate, if the works eventually fell into the public domain, the underlying works, and do a different compilation. And let me just jump. Yeah, go ahead, Fred. I'm sorry.
I was just going to say, meanwhile, there is no additional protection in the individual piece that's in the collection. It is what is protected is the collection itself.
Right, not and the way that it's arranged. Yep, not the underlying works. Well, yeah, so the Mark Twain question, I'll just take that and then I'll let you take it back. So 303 of the Act actually specifically addresses what happens when a work had been created before 1978, the effective day of the 76 Act, but it had not been published or registered. So it was not yet a copyrightable property before the 76 Act became effective. It actually, at that point in January 1, 1978, it got copyright under the new law, so life plus 70. So what happens when the person's already dead in the case of Mark Twain? There would be no copyright except for the fact that there is a provision that says that in no case shall the term of copyright expire before December 31, 2002. So if so that work would have had copyright until 2002, okay, the Mark Twain work. However, if it was published before 2002, and it doesn't sound like it was, but if it were, then the term of copyright would expire in 2047. So that's one of those weird rules that somehow found their way into the Act that's very arcane. So you'd have to look at the facts behind the Mark Twain book that somebody asked about.
Yeah. How can an archive or museum claim a copyright in a historical photo produced in the 19th century?
Ooh. They can't.
Right.
But what they do is they require you to sign licenses. I've seen this a lot, and writers come across this a lot because they're trying to get, photographs to use in their books, and they have to go find the photos and clear the rights. And the archives will make you sign what they call a license and pay a fee for it. Actually, all you're paying for is the right to access to that photo.
Right, and the copyright notice is actually not accurate. The copyright notice is incorrect.
Mm-hmm.
But this is a way of museums and archives trying to preserve that which they have, which is access to unique materials. They don't have copyright protection. There's a very long question about the public domain coming up, and the answer is about the Gutenberg project. There, to my knowledge, and maybe the Authors Guild knows better, but to my knowledge, the Gutenberg project, which is now available pretty much only online, although I think they still have a physical place out in California, is quite diligent in clearing public domain, in confirming public domain status of works. And so materials that are accessed from the Gutenberg project, subject to, I guess they do have a license asking you to give attribution. You can use public domain materials, usually old materials, 19th century and earlier, without hindrance. The Gutenberg project is specifically designed to make those materials available for the use of everybody. All they're really looking for is a credit so that maybe somebody will give them more money because they do need more money to do the very good work that they're doing. Okay, there's I guess a question for you, Mary. There's a question: if I write a freelance piece for a newspaper or a magazine, do I own the copyright? What about if I'm an employee? All right, I answered the question about if I'm an employee. If you're an employee and your job includes having to write, and you write for your job, you are the writer, you're not the author, your employer is the author. However, the more important part of the question is, what if you're a freelancer?
Okay, so if you're a freelancer and you don't sign a contract, you as the author own the rights, okay? Because the rights initially vest in you, and you haven't assigned the rights to the periodical. And if there is no contract, it will be considered a limited, non-exclusive license that you've given. Now, there are very few publications out there that are professional in business that won't make you sign something. And many, if not most, freelance, well, it depends on the type of magazine, newspaper, journal, but the contract will ask for an assignment of rights. It used to, or an exclusive license. It used to be exclusive license for a limited period of time. That's what they should say. I've recently seen more freelance agreements that are asking for assignment of all rights and basically everything you've ever written. I'm being facetious there, but do push back on that, and the publication should get an exclusive license. That means that only they can publish it for at least a limited amount of time. Obviously, they're paying you for the piece. They don't want other people publishing it too. Sometimes, again, depends on the outfit, but you can, for if they're going to give you a lower fee, they get fewer rights, less time, maybe even they get non-exclusive. I've seen things where, a website wants it for a short exclusivity period because they want to pay you a lot, and then they allow you to sell it elsewhere. The problem is it's hard to sell something once it's been published once, which you know well. You can also negotiate sometimes the ability to put it up on your own website. But it depends on the contract is the bottom line answer.
Right now, Mary, I see one more question that I think we have not yet answered. So that we'll do that now. But I think if anybody has a sort of last-ditch question, it's 3:50, and we imagine a lot of you would like to go on to do the rest of your day. So do drop your questions pretty quickly into the chat box while we try to address the one last question, which will probably only take a minute or two. And that question is, Mary, you probably get this at the Guild all the time. If I, as the author, have been given material to use in my work, but I don't have written permission, what should I be doing?
You should be getting written permission.
Yes.
Yes, because if you don't, you might be able to, if there's a lawsuit later, prove through circumstantial evidence that you had an implied or an oral license, generally an oral license, but you don't want to be in that mess. You don't want there to be any disagreement. So get it in writing. If it's too, if you can at least get an email that says, I give you the rights to use this, and it has to be what the use is. It has to clearly define your use, and everything that you need. That can be, if it's sent and signed electronically by the person giving you the rights, that can constitute a contract. However, generally speaking, it's better just to do the, old-fashioned contract, make it nice and clear, and then you won't have a dispute down the road. And if you're publishing with a typical publisher, they're going to want to see that.
Yeah.
They're going to want to know you have the rights.
Question here from somebody who may know something about foreign copyright. Under United States copyright law, a photograph gets the same term of protection as a text or other kind of work. That is not true in every country. It is true in the United States.
That is correct.
Can we cite statistics that we find in an article, such as statistics from a Pew Forum survey, going back to the list of things that are protectable by copyright and those that are not? If these are facts, that is 30% of Americans are taller than 6 feet, the fact that it was published in a Pew Forum survey does not give them any copyright protection. They're still facts. If what you're looking for is Pew wrote an entire paragraph explaining the significance of the fact that 30% of Americans are more than 6 feet tall, that's a statistic, but it's embedded now in copyrighted material, and you can't take the copyrighted material or the copyrightable material. The specific piece of data, the specific fact, standing alone, not protected. The material that may explain the fact would be protected.
The next question is, what if they generated the stats through their work? There are a couple kind of weird cases out there where people try to claim copyright and successfully did claim copyright in ratings, not statistics, but ratings, claiming that the rating itself was a compilation. Those, I think those cases are not good law, although they stand on the books. But a statistic, even though it's generated through their work, generally speaking, is going to be considered a fact. With those, but admittedly, there are those couple of outlier cases.
And some of them are pretty famous. I mean, the question, for example, what was the name of Jerry Seinfeld's sidekick in the television program? Whether or not the name George Costanza is a fact, when there was no human being with that name ever in the universe, in theory, it was the subject of a very strange case, which is very well known in the copyright bar, that a lot of people sort of like the answer to because they like the program, but as a copyright matter thought was kind of messy as to whether, the names of characters just standing alone, for example, the names of characters or situations that characters are entered into, as was true in a television program, whether those are protectable creations or unprotectable facts. Tough case. And as they say, you know, hard cases make bad law. So I think if you're in that situation, I think Mary's answer is the right one, which is if it's a statistic about something in the world, the fact that you work to generate it doesn't give you any more or less protection. If it's merely a fact, it's merely a fact and not protectable. But if you're really on the cusp of those kinds of things, because it may depend on where you live and it may depend on the circumstances, do seek some counsel to parse that through.
So I'm just going to jump back up, if it's okay, to a couple of questions I think we skipped that I think would be helpful just to clarify. If somebody asked that if a book was published in '97 prior to the '98 law that made life plus 70 from life plus 50, do you get the life plus 70? Yes. So anything that was still under copyright when the term extension was passed got the benefit of the term extension. So every work that was created post-1978 does have life plus 70. If it's created by an individual, not a work made for hire. Fred explained that the terms for work made for hire are a little different. Okay, there was another, okay. Somebody asked if posting on a website is considered publication. Again, so the definition of publication is really unclear in terms of how it's applied to the internet. Not really unclear, but by and large, what it means is that it's got to be distributed in copies. And publishing something on a website where it's freely downloadable, or meaning it can be printed out or it can be downloaded to your computer, that is generally considered a publication. So if you've got a website that's open to the public and you don't have any kind of technical protection measures that prevent printing and downloading, then yes, it is going to be publication.
Okay. For some reason, a couple of questions came through to me directly on email that I just found, but thankfully, those of you who sent them figured out to put it on the chat box. That was a lot better. Thank you. And I think we're done. It's just coming up to 4 o'clock. Again, we thank you all for participating this long. I think I speak for Mary and Ryan, the folks of the Authors Guild, and the folks here at Copyright Clearance Center, that we're really pleased to be of this service to you, and we look forward to seeing you next week. Thank you.